Hello and welcome everybody to today's FISD webinar from the Alternative Data Council on web data collection and interacting with Robots.TXT. I'm Tracy Shumpert. I am the Vice President of Membership and Programs here at FISD. This program would not be possible without our incredible sponsors. I'm going to introduce them. SIBO, CME Group, FactSet, and SIX, as well as our sponsors, Google Cloud, Refinitiv, and S&P Global Market Intelligence. So we're going to do something a little different today. Typically, we do this during the registration process, but today we'd like to ask your permission live to be able to share your information with our sponsors so that we can keep doing programs like this one. So could we have the survey? So this consent would be to have the sponsors that I just listed contact you. It's completely the same thing that you would have consented to in registration previously. We're just trying a different way. We'd be very grateful if you would allow them to do that. So thank you so much, but you can continue listening to the webinar either way. So I think we will move forward. So just a couple of standard things that we always have to mention. SIA, which is FISD's parent company, has an antitrust compliance policy. I don't think this is strictly needed, but just to say it out loud, please do not collude. Thank you. Also, as a courtesy to our speakers, please do not quote or otherwise treat this event as anything other than off the record. If you do want to quote or speak with our speakers, just let me know and I'll put you in touch. Thank you. However, you can stay connected with us through social media. We have many challenges with people getting communications from us because everyone's spam filters are getting better and better. So if you're not sure what's going on, you can always check social media. Thank you. I'd also like to thank some of our new members. Hopefully, if you have a chance to interact with them at an online webinar or something like that, you'll say hi and welcome them to FISD membership. I'm not going to read them, but just thank you so much, everyone. And now I would love to introduce you to Gina Demento, who is the Chief Compliance Officer at Point72. She is an extraordinary intellect and has been participating in our alternative data procurement stream for quite a while now. She is going to lead you through sort of an overview of the Alternative Data Council's work and what we've been doing in web scraping particularly. So Gina, thank you so much, and over to you.
Thank you, Tracy. The FISD Alternative Data Council, through the creation of multiple working groups, has continued in its efforts to create a collaborative and effective environment for the industry in its efforts to achieve multiple goals, such as lowering costs for the benefit of end clients, facilitating growth in the industry, driving adoption of alternative data in the investment process, and promoting the ethical use of data. Working group members comprise of all sides of the industry. Currently, we have over 30 buy-side members representing over 10 trillion in assets under management, over 20 vendors, and more than 5 data sourcing platforms. These working groups have already drafted and published materials that are actively being used by industry participants. Some examples of these are data vendor tear sheets, due diligence questionnaires, data buyer checklists, web data collection considerations, trial agreement, a sample trial agreement, and buy-side guides. Additional standards, best practices, and information materials are being created now by these working groups for future publication, such as Data Information Package, REST API standards, the Phase 2 of web data collection, and communications best practices. Since we're focusing on data on web scraping in this event, let's take a closer look at the topics that the Alternative Data Council, and particularly the web scraping working group has already collaborated and published on. On the left, you'll see the previously published items. There's consideration of terms of service, the use of proxies when performing web scraping programs, volume and addressing sensitivities relating to frequency in which a program hits a site to prevent adverse impact on those sites, Robots.TXT, which Stacy and Jeff will dive deeper into further this morning, and copyright considerations and applicable privacy law. Currently in development and topics you should expect to see in the future include CAPTCHA, cease and desist, do not compete, and the application of international law. What remains lacking is regulatory guidance. The industry has been craving regulatory guidance as it relates to web scraping for some time. The FISD Alternative Data Council working groups are comprised of participants across the industry that each view these topics from their own personal lens. However, all of these members have common goals, whether they are buy-side, alternative data providers, or platforms. Buy-side business and legal personnel want to avoid regulatory and reputational harm. Data vendors and data platforms want to act fairly and remain competitive. These guidelines, all that have been published, attempt to establish a baseline of fair and lawful behavior in the face of legal and regulatory uncertainty. So how should these guidelines be used? Every vendor and every buy-side firm has different tolerance risk, has different risk tolerance. The guidelines are meant to provide a baseline for fair and lawful behavior in the face of legal uncertainty. They also seek to allow access to data without harming website operators, consumers, or other stakeholders. Although these guidelines are not best practices, they should be able to help firms identify a set of permissible scraping practices that they can use in their business. In addition, these guidelines may also be leveraged for use when evaluating vendors providing data sets sourced to web scraping. With that, I'll hand it back over to you, Tracy.
Thank you so much for that, Gina. So before I introduce Stacy and Jeff, I just want to give you a tiny bit of background on how this came about. So Stacy and Jeff are members of the Alternative Data Council procurement stream, which has been working on web scraping for about the past year. And as part of our activities within the working group, Zwilgen, their firm, provided a really great overview about just that illustrated interacting with Robots.TXT just really beautifully. And we wanted to be able to share it with more than just the folks who were on the call that day. So that's really how this webinar came to be. I also want to mention it's a relatively succinct presentation, so I don't expect this to go the full hour. We'll have time for Q&A. So if you have a question for Stacy or Jeff or Gina, they'll be hanging on at the end with me, and we'll be happy to take questions. So with that, I would love to introduce Stacy Brandenburg and Jeff Landis from Zwilgen. They are fantastic, and I think you're going to love this presentation. So I will hand it over to the two of you and speak to you at the end. Thank you.
Thanks, Tracy, and thank you, Gina, for helping to set the stage about some of the work with the Alternative Data Council. We've really enjoyed participating in the work that the group is doing and the opportunity to be here and talk with this group today. As Tracy said, we have had an opportunity to meet some of you before in the context of either our prior presentation or the work we've been doing, or as clients and others in the industry. But we thought it would be helpful to take a minute or two as an introduction just to tell you a little bit about our firm and who we are, because as Gina was saying, everybody does bring their own lens to this analysis and set of risks. And our role here as outside counsel, both to vendors and to those who are purchasing alternative data, is to help understand the risks, the evolving landscape, and to arrive at a place that is comfortable for whoever it is who we're working with, because everybody's risk tolerance and set of considerations can be a little bit different. And so our firm, just to give you a little bit of background, Zwilligen is a technology law boutique. So we deal with all issues pertaining to data, and those include regulatory issues, privacy, security, class action litigation, law enforcement requests for data, and of course, the alternative data space, where we've been advising both funds and providers of data for, I would say, 5 or 6 years. For myself, I come to this space with a background as a litigator, and then I was at the Federal Trade Commission in their privacy division for a number of years. And so bring to a lot of these issues the perspective of a potential regulator, as well as looking at some of the diligence concerns that may trigger privacy issues or security issues. And so not securities, but security, particularly when you're collecting data that may have sensitive information in it. So with that, I'll turn it over to Jeff just to share a little bit about himself, and then we'll get into our agenda.
Thanks, Stacy. So this is Jeff. As Stacy mentioned, we all sort of come to this with a slightly different lens. I'm chair of the firm's litigation group, and so as such, I sort of tend to approach these things with an eye towards litigation risk. I've been doing class action litigation my entire career, the last 7 years here at Zwilligen, doing privacy class actions. But with that, like Stacy said, the last 5 or 6 years, also advising folks on alternative data and risks, particularly really focusing on the potential litigation risks, some of which we'll talk about today.
Great. So our plan is to go through some web scraping basics, just because the Robots.TXT discussion really is against that backdrop. Make sure we all understand what we're talking about when we use the phrase either Robots.TXT or Robots.TXT. We have an analogy to share, which, if you'll bear with us, we hope will be helpful in thinking about how you approach a Robots.TXT protocol. And then look at how industry and courts have addressed the use of or adherence to a Robots.TXT. And finally, ask a couple questions about practical implications and what does this mean for you? So just to level set, when we talk about web scraping, there are a lot of different concepts about what this means, just in general parlance, but what we're really talking about is the automated collection of data. And what this often can allow you to do is to access unstructured data and convert it into a more usable or easily accessible form. So just to give a quick example, when you go to the Gap and look on your web page at the shirts and the prices, all of that data is being rendered to you in a format that is accessible to a shopper, to a consumer. But the data and information on the back end is also accessible. It's just needs to be accessed through a slightly different avenue. And so sometimes what web scraping is doing is gaining access to that same information that's being publicly available. It's just being viewed through a different lens. And you use a bot or an automated tool to do that and be able to process and access data at a higher volume. So sometimes we get the question about whether doing this manually versus doing it in an automated form would change the analysis. And many of the same questions apply. Sometimes this question about automated access is likely to trigger a terms of service. And so you may be implicating some considerations there. But otherwise, many of the key questions are still the same. And we'll talk about access and authorization, which are often the underlying key legal elements for this whole conversation. And the Robots.TXT factors into that. So we'll explain how it fits together in a minute.
So what's the legal framework for web scraping? I mean, one of the trickiest and I think most interesting parts of web scraping is that it's a very widespread practice, but as Gina noted early on here, there are no really rules, regulations, statutes designed specifically to address web scraping. So there's nothing that says X is okay, but Y isn't, do this, don't do that. And we're all sort of creatures of habit. We like some guardrails. We like to know what we can and can't do. So the sort of lack of framework, I think, gives some consternation to folks. But there are a number of laws or potential claims that can be implicated based on sort of a number of factors, right? How the data is accessed, where it's located, how you use the data, the relationship between the scraper and the scrape sites. All these things sort of affect the potential exposure for scraping. But there are, a handful of claims and statutes that are most come up most frequently. And the first is the CFAA, which is the Computer Fraud and Abuse Act. And I think this is the one that gets the most press, or people are often most worried about, because it's a criminal statute. It was designed for, hacking, as an anti-hacking statute, but has evolved a little bit. But, it's a criminal statute, although, people are not usually prosecuted criminally for web scraping. Instead, the CFAA and scraping comes up in the civil context, because you can also sue someone civilly under the CFAA. And the key question under the CFAA with web scraping is, are you acting without authorization or exceeding authorization when you're sort of accessing the data at issue? And that's the key question there. Copyright law and copyright violations are also implicated when you're performing scraping. And there, that comes up if you're scraping and then republishing the material. If you're not republishing it, copyright is less relevant. You can also find yourself on the wrong end of a breach of contract claim. So if you agree to a website's terms of service and the website says no scraping, you are technically in a breach of contract. So, the way that the main issues with respect to breach of contract claims are really, did you agree to a contract to begin with? And, this gets into questions of, if you just go onto a website and it's a browse wrap agreement, have you actually agreed to the terms? Or, if you don't click I agree, can you be bound? Sort of contract law. And the second issue that often comes up in the context of breach of contract is there any damage to a website or the provider of the website by the scraping? In most cases where breach of contract comes up, it's usually a competitor scraping the website of one of its competitors to gain some kind of advantage against them. And then the fourth sort of bucket of claims is trespass to chattels. Really, that comes up when you're likely not in a contractual agreement with the website, but the scraping is slowing down or otherwise harming the website. And so, all those are different laws or statutes that could be implicated. But the presence or absence of technical measures or signals like Robots.TXT really come up with all these types of claims. And so that's what we'll discuss today.
We should say that we could do an entire hour on web scraping and the legal framework. And I think one such session actually has already been done, but we did think it's helpful just to level set, because thinking about what the relevance of Robots.TXT, you have to think about it under the context of each one of these legal theories that Jeff outlined. So in short, what is it that we're talking about? A Robots.TXT, it's just an advisory text file. It's a little bit of code that usually appears in the top level directory of a website that is there to request or communicate a certain preference to an automated web visitor like a spider. And it is generally considered to be an announcement of etiquette. So and there's one case quote there, that it's a convention to instruct cooperating web crawlers, note the word cooperating, web crawlers, not to access all or part of a website that is publicly viewable. So, and I just want to stress that again, with the caveat that we're not giving legal advice here, this is just informative, but that the general consensus is that this is just an etiquette and it is not an access limitation or something that is designed to establish legal limits of access. And so with that, let me, if you'll humor me. So imagine that this is in the pre-COVID world or post-COVID, and I am having an open house and you come for a visit. When you arrive, you notice a small sign that I've posted in the hallway saying guests are requested to please use the hall and downstairs bathrooms only. You could read it a different way, which is please don't use the upstairs bathroom. So you notice this sign, and for whatever reason, you choose to disregard it. You go upstairs and you use the bathroom upstairs. So the question is, have you violated any laws? Do I have any claims against you? You saw the sign, you disregarded it. I think the answer is no. You simply disregarded a request, or one could even go so far as to say it's a form of etiquette. Most people know that the upstairs bathroom is reserved for the residents of the house. As a guest in someone's home, you don't usually use that one. Now, the fact that you've chosen to disregard my request doesn't change your right to be in my house, to eat the food that I've set out for everyone. And, to take the analogy one step further, I might gently ask you next time, please use the downstairs bathroom, or I might even kick you out and say, hey, I'd rather you leave now. That last step is probably an overreaction, both in real life and online, but it's certainly, my option. But at the end of the day, the likelihood that you violated any legal requirement or that there's a claim I have against you is very low. So now let's go to an alternative. So now tweak the scenario and imagine that you get to the upstairs bathroom and you find it locked, and you break through the door and you went inside and you use the bathroom, and as you're leaving, you leave the sink running. Okay, now what? This seems like a different situation. You have clearly broken through an established access restriction. Everybody knows a locked door is not intended to be opened, and certainly not by breaking it. You've also damaged my property, and you've probably cost me some, unnecessary water bill expenses by leaving the water running. So do I have a claim against you now? Well, I think it's more likely, probably in connection with the damage to my property. And if you bear with the limits of the analogy, and accessing a part of the house that was locked and to which access was clearly not granted. But none of those claims, which you might have, really rely on the hallway sign that requested you to not use the upstairs bathroom. Now, that may be an additional factor in suggesting that you knew you weren't supposed to be upstairs. And then when you encountered the lock, it's another factor. But it doesn't change the underlying authorization. You were still authorized to come into my house, and there were no unequivocal restrictions about where you could go. Again, it was just a request. So as we think about Robots.TXT, this is in many ways how it functions. It's simply a request. And whether there's an underlying legal claim really relies on other factors to get there. So, and if you look at the way that industry has categorized or approached the Robots.TXT, it echoes the same concept. Now, on the face of it, it may seem like an access restriction or even a technical one, but there's no law that says it must be obeyed. And if you look at the industry writings, the robots.txt.org, if you look at Google proposed a standard to help, if you want to implement a robots.txt on your site, what that would look like. And even there, they've clearly said that the rules are not a form of access authorization. It's simply a way to communicate preferences to scrapers and crawlers online, because what it really is designed to do is to prevent indexing, to say, I don't necessarily want my information, I don't necessarily want my information broadcast to the world. It's great if you know that you're coming to find me, and I want that information to be available to anybody who knows to look for it. But I don't need, the location of every Starbucks, for example, to be broadcast everywhere. That's the kind of example where an indexed crawler would be very useful so that you can easily find your Starbucks. But say you don't want that, then the robots.txt is designed to communicate to the crawlers, this information it's not our preference to have it broadcast in this way. But it doesn't preclude you from doing it, and it certainly doesn't preclude you from scraping it and using it internally. So, when we think about how this fits in with the CFAA and what Jeff was saying, we just wanted to kind of talk about the CFAA framework a little bit more, because I think it's fitting this in is another sort of important piece. And historically, this question of authorization and unauthorized access under the CFAA has fallen into two camps. And one is this access perspective, which is, again, the idea that the information is available out there, regardless of my preference. It's available to the public, and you can't limit that. And that's sort of the access perspective. The internet's a public square. And if you listen to some of the arguments in the Supreme Court's Van Buren case, which is up before the Supreme Court, and we're waiting on a decision any day now, that deals with the CFAA. They get at this question about whether a mere articulation of limitations on access to public information is going to be sufficient, or whether, as in the property perspective, it may result in some extreme conditions. And the property perspective says, it's my information, I'm putting it up available on a website, I get to decide who can access it and for what purpose. And one of the problems with that is it gives a site the ability to say, I don't want no left-handers, or I want to use sort of arbitrary restrictions. And in today's world in particular, that's no longer as tenable as it once was. So the case law is moving more in the access perspective direction, where you need to have, if you're going to have an articulation of a restriction, it has to be backed up by some sort of technical measures. And that could be a robots.txt, although we think by itself it's probably not sufficient, but that's the kind of possible restriction that may layer in, like back to the home analogy. It could be one of a number of factors, along with the locked door and other things, but by itself it's not likely to be sufficient. The last sort of footnote, though, is that even now for publicly available data, and this follows on after the HiQ LinkedIn case, even that may not be enough for data that's available to any member of the public. And so even having sort of limits, both technical and sort of written restrictions on access, may not be sufficient for that kind of data. So when we're thinking about robots.txt, again, we can kind of think about it against this framework. Jeff, do you want to talk about how the courts have viewed robots.txt?
So, I mean, the short answer for how courts are treating robots.txt is it's not dissimilar at all to how industry is. The presence or absence of robots.txt isn't going to be dispositive for any of the different types of legal claims we just talked about. But it is a relevant consideration that we see come up in the case law sometimes. And so starting with the CFAA, Stacy just mentioned, the key question there is whether you're, acting without authorization or exceeding authorization to access the data. And to determine that, what courts look at often is the presence or absence of a technical measure limiting access to the content. Now, again, the most sort of obvious technical measure is a password. But, what about robots.txt? I mean, technically that's a technical measure, but is it sufficient to create CFAA exposure by itself? And, as sort of you probably guessed by now, the short answer is no. In the absence of other factors, ignoring a robots.txt is likely not enough to constitute a violation of the CFAA. And again, that's really because of the fact that it tends to be viewed as a purely voluntary measure. And in fact, the HiQ case, which as Stacy mentioned is sort of one of the leading cases right now on web scraping, specifically said that adherence to the rules in a robots.txt file is voluntary. And again, in that case, the court drew a distinction between publicly available information accessible to anyone without creating an account and information requiring special permission, for example, something behind a paywall or password protected. And that court said that scraping publicly available information, even in the presence of a technical restriction, is unlikely to give rise to a CFAA claim. And so you can see that a voluntary restriction like robots.txt is even less likely to give rise to a CFAA claim. So, again, that seems, lower risk in the context of CFAA. Okay, what about then copyright claims? Again, copyright comes into play more when you're reposting or redistributing a particular work. So it's if you're scraping data for internal purposes such as investment analysis, copyright and the laws prohibiting copyright violations are less likely to come up. But if you're republishing it, copyright law does prohibit circumventing a technical measure that, quote, effectively controls access to a copyright protected work. And so again, we're sort of back to where we were with the CFAA is, are you circumventing a technical measure under copyright law? And, under the copyright law, circumventing a technical measure means to descramble a scrambled work, to decrypt an encrypted work, or to otherwise to avoid, bypass, remove, deactivate, or impair a technological measure without the authority of the copyright owner. And that's what the statute says. So again, you can see if you're avoiding, bypassing a robots.txt, it could theoretically fall within that definition. And the courts have been pretty inconsistent about whether the presence or absence of robots.txt means someone is or is not circumventing a technical measure under the copyright law. So we have this DHI group case, which was in the Southern District of Texas. There, the court said that a robots.txt file could be considered a technical measure that controls access to a copyright protected work. So it denied the defendant's motion to dismiss a copyright claim under the DMCA. Now, that was at the very early stage of the case. The court didn't sort of reach the actual question of whether or not, in fact, ignoring a robots.txt file was circumventing a technical measure, but it said it could be, so the court denied the defendant's motion to dismiss. Or similarly, in the Timburo case, which I think Stacy alluded to earlier, the court was pretty clear that the failure to use robots.txt exclusion, so sort of if you don't include it, it doesn't automatically mean that the website creator has sort of given up their intellectual property rights or invited the public to copy the material. So there, the court said, well, just because you don't have one doesn't mean you've given up your rights to protect copyright material. But then, sort of throwing that into flux a little bit, the court in this Google case reached a little bit of an opposite conclusion. And there, the plaintiff alleged that Google engaged in copyright infringement by providing cached links to his copyright works on the Google search engine. But there, the court sort of took the opposite approach. It pointed to the fact that the plaintiff added a robots.txt file to a site to ensure that search engines could, that his site would be included in search listings as supporting Google's arguments that it engaged in a fair use of his works. But then the court also pointed out that that robots.txt file didn't include a no scraping instruction as supporting Google's argument that the plaintiff was stopped from arguing Google didn't have permission to provide the link. So it sort of went the opposite direction at an early stage as from the DHI and Timburo case. So again, much like sort of the law of scraping generally, there's no one answer for what the presence or absence of robots.txt file means for a potential copyright claim. You have to sort of look at the fact pattern holistically and evaluate it sort of with a whole bunch of other factors when you're, evaluating the legal exposure you could face for scraping. But again, if you're not republishing the material and just using it for your internal purposes, copyright becomes less of a concern. And then, finally, trespass is another claim that often comes up with scraping. It most often comes up when you're scraping a website, but that you don't have a contractual relationship with the website. And here, the few courts that have looked at the issue have said that sort of the presence of a robots.txt isn't dispositive or doesn't, affect greatly the trespass analysis. And that's really because the main question with trespass is whether the scraping has caused a website to suffer some sort of irreparable harm, reduce system performance, system unavailability or data loss. And if you just think about it practically, whether or not there's a robots.txt included in the site doesn't really impact whether or not your actions are harming the site. And I mean, that's sort of the reason we always recommend, that you try to make sure your scraping activities aren't burdensome or harmful to the target websites. Because in addition to kind of being a red flag announcing what you're doing, it does give rise to a potential trespass claim. But again, the presence or absence isn't really relevant to whether the activity is harming the operation of the site. But it could be relevant to a breach of contract claim if you agree to the terms of service that have a no robots.txt provision. But again, you sort of get into the fact that, is it just a request? If you don't actually agree to anything and it's just a request, could you even potentially be breaching a contract? And there's also issues or questions of, whether you've actually damaged the scraped website, right? In order to have a breach of contract, there has to be a contract, you have to breach it, and someone has to be damaged, which is why, again, as I noted earlier, you often see these claims come up in a competitor case where you're using someone's scraped data to compete against them. That's a form of damages, as is operation of the website being hindered. But again, if neither of those things are present, it's me harder to prove damages.
So taking this all into context, what questions do you need to ask yourselves, among other considerations for web scraping, about how you handle a robots.txt if you encounter one in the course of the scraping you're doing? And we just listed a few questions that we would anticipate would come up as you develop either your own internal guides or you're diligencing somebody who might be web scraping. And the first one is, do you need to check for a robots.txt? And ultimately, of course, every scraper and organization needs to make its own determination, but we're not aware of an affirmative obligation to look for a robots.txt. Of course, next question is, what happens if you encounter one, and what are your obligations there? And it seems like you have three choices. You can adhere to it. You can adhere to robots.txt in some situations, like where maybe you're scraping content behind a login. If you do that and you feel that that's already a slightly higher risk activity, so you want to be a little bit more conservative on the robots.txt approach, or you don't have to adhere to them at all. So what are the implications of each of those approaches? If you decide not to respect it, as we've talked about, it's not clear that there is another risk absent other activities. And, the site might kick you off, back to the sort of bathroom analogy. They may ask you not to come back, even where you did no harm to the site or to the house. But it could be taken among other factors to contribute to other claims, or be used to build a claim, as we've been talking about, and as Jeff highlighted in some of the cases that have involved robots.txt. But your response to the robots.txt alone is not likely to be the basis of the claim. So sort of how you choose to respond to it may really be affected by the larger context. Now, as Jeff had alluded to, there may be benefits to voluntary adherence for deciding that you want to honor the robots.txt requests, even if you may not be required to. And for example, from the CFAA context, courts have found that where a scraper does respect robots.txt, that may be a factor in support of a scraper's lack of intent to harm the site. So if the scraper didn't do things well otherwise and had some either intentional or inadvertent impact on the site, maybe the fact that they chose to honor the robots.txt can weigh, thumb on the scale in favor of this was an accident, this was not systemic, whatever arguments you might want to make to say this wasn't some intentional harm to the site. Similarly, for the DMCA, there's a question about whether the robots.txt effectively controls access. And as Jeff explained, that's really a very fact-dependent component or analysis. Now, the reason that may be useful is that, as Jeff described, it could increase the litigation costs. And if it does that, because you can't resolve the whole situation on motion to dismiss, it may discourage a site from bringing a lawsuit in the first place. So your decision to adhere to the Robots.TXT may help reduce sort of litigation costs or that path. Again, very fact specific, and you have to sort of know who you're dealing with. But and the third situation is in the trespass case. Again, agreeing to the Robots.TXT could help refute a claim that you were not permitted to be on the site, because the idea is that the site could have known that you were there and kicked you off. So, you know, the Robots.TXT, I think, gets a lot of airtime, and maybe more than it really warrants given the possible implications, but it's not something to be ignored either. And so we hopefully this sort of introduction to it or overview of it has been helpful. It is something to think about as you build out your web scraping protocols, one of many other factors. So I'm going to pause here, see if Jeff has anything else to add, but otherwise we're here for questions, and we really appreciate you taking the time and listening to our discussion here.
Yeah, this is Jeff. I mean, I don't have anything else to add, Stacy.
Okay.
Thanks.
In that case, thank you so much, Stacy, and thank you so much, Jeff. That was great. So just a couple questions that have sort of come through on the side. You mentioned that there is a case pending in the Supreme Court. Do you have well, clearly you cannot read their minds, but do you have any sense of what may be coming, or perhaps more practically, how you're hoping that decision may turn out, and how it could affect people's ability to web scrape?
Sure. So the case is Van Buren, and we're expecting a decision in the next few weeks. Based upon the arguments, that just to back up for a second, the case involved the CFAA, but it involved an employment context. So an employee arguably exceeded his authorization by using access to a database that he was authorized in the course of his employment to get access to, but he used the content for purposes that were unauthorized. So basically he found the names of some individuals in a driver's license sort of database and gave that information to a non-employee. And I explained the context in part because the court, if it chooses to, could sidestep most of the issues that impact this group in talking about the CFAA and really limit its ruling to sort of the employment context. However, the questions that came up during the course of the argument did ask some of these questions about how can you render people in violation of a criminal statute for merely violating terms of service, particularly even if it's a browse wrap on a publicly available website. So there might be an opportunity for some dicta at a minimum to talk about why web scraping of publicly available data should not be a violation of the CFAA. LinkedIn, the HiQ LinkedIn case was also appealed to the Supreme Court and has been, they haven't officially stated, but is sort of waiting to see whether cert was granted until after Van Buren is decided. So it very well may have an impact on what we're all doing here. The court seemed more favorable towards a more permissive web scraping approach, at least again, in terms of the CFAA risk. That doesn't mean that you don't have a serious other claims, particularly for entities who are not like us, who may be republishing or using the data for competitive purposes or things like that. But we'll see. It's the first CFAA case for the Supreme Court. So.
Well, great. Well, thank you so much for that. And so this one maybe is a little bit for Gina, but Stacy and Jeff would also love to hear your thoughts if you're able to say. So the questioner says, the web scraping is a very popular category of alternative data, and yet for regulated financial institutions, there's not a heck of a lot of guidance out there right now, except for what you guys mentioned. How do you see buy-side firms who utilize web scraping to make investment decisions, determining, the risk in an opaque environment? And what do they do to make that assessment easier?
So from our perspective, it's quite different depending on the risk tolerance of each firm. Our risk tolerance remains conservative, and for that reason, we apply a bar that keeps us as far away from any line find. But I think each buy-side firm has to conduct their own analysis and see how comfortable they are. But I would be interested in hearing Stacy and Jeff's opinion as outside counsel advising buy-side firms.
I mean, this is Jeff. I mean, I guess, as you mentioned, Gina, I mean, everyone has sort of their own risk tolerance. I mean, I think that one way this comes up frequently for us is a lot of folks seem, particularly given the lack of regulatory guidance and sort of guardrails, more concerned and more focused on, sort of the reputational risk and the fact that, something that is high profile or just sounds bad and poses a reputational risk may be more likely to draw the eye of a regulator, even though the conduct itself is not really any different than something that just seems more benign because of the type of data. So I think people tend to focus more on the reputational risk and sort of the, front page risk to drive the concerns about about regulatory risk rather than the other way around, if that makes sense. I don't know, Stacy, if you have different view.
No, I agree with both of you on those points.
Great, thank you. And then just a final question. Do you, and this is really open to everyone, I mean, the Alternative Data Councils created a couple of years ago to do what we could to streamline the process of evaluating alternative data and enabling firms to consume alternative data really for the benefit of the entire industry. Do any of you have an opinion about the role that the industry itself can play in sort of ensuring the future of web scraping in particular?
I think that the efforts that industry have made so far to harmonize some of the communications and the language and coming up with some common approaches, I do think that is likely to be helpful. But both because it conveys a common understanding of what the parameters or bounds of the law are, and also because I think from a regulatory perspective, it's harder to reject an approach of an entire industry outright. You might need to incrementally change things or adjust things, but I think there is more likely to be some group protection, at least in the first instance, by having sort of a common understanding among those who are closest to these process on all sides of it about what's practical, what's legal, or ethical within this space.
It can also discourage bad actors who are then more likely to sort of draw regulatory scrutiny by having sort of an industry practice or standard.
Great, thank you so much. So that is the end of the questions I've received. But since we're together, Gina, Stacy, Jeff, do you have any last words or messages for the audience?
No, but we appreciate the attention and decision to join us this morning. And certainly for us, if you do have additional questions about any of these issues we've raised or anything pertaining to the alternative data space, we'd be happy to continue the conversation offline.
Great, then. Thank you so much, Stacy Brandenburg, Jeff Landis, and Gina Demento. You're fabulous, and thank you for spending time with us today. So let me just lead us out. So if you enjoyed this, we have a bunch of other activities coming up over the next few weeks that you can see there. And we'd love to know specifically what you thought of this event. We definitely review your responses and use them to create future programming. So please fill out your event survey when you get it. I'd like to say a final thank you to our sponsors, Google Cloud, Refinitiv, S&P Global Market Intelligence, and our global sponsors, SIBO, CME Group, FactSet, and SIX. So this is the conclusion of this webinar. We hope you really enjoyed it. If you are interested in the publications of the Alternative Data Council or would like to join the Alternative Data Council, it is open to all FAISD members, and feel free to ping me and I will be glad to tell you about it and invite you to a future meeting. So everyone, have a great day. Thanks all for joining and hope to see you again soon. Take care, everybody.